and your life.
Welcome everybody to the third meeting of the Short-Term Rentals Working Group. My name is Brent Stockwell. I'm an Assistant City Manager here at the City of Scottsdale. And all members of the working group are present with the exception of Council Member Linda Milhaven and Member Joe Aturi, who let us know in advance that they would not be able to attend this meeting, but would be reviewing it on the YouTube channel after the meeting. So we're going to go ahead and get started. And with all of our meetings, we've basically set aside about an hour and a half on this. And so we're going to plan on having our discussion and wrap up by around 5 o'clock, if possible. Just as a reminder, the group purpose is to examine existing laws and tools available to the city regarding short-term rentals. And the group is working together to identify opportunities for the city to improve monitoring and enforcement of regulations to ensure Scottsdale is doing everything it can to manage the impacts from short-term rentals. As I mentioned, we are 3 meetings in. At the very first meeting, we went over a 6-meeting time frame, and we're on track. The key focus for today will be to review kind of the grouping that staff has done of the comments received and made by the working group at last meeting and get additional feedback on that, and also review any additional public comment and other information provided to the working group and received by the working group. The first item is public comment. We did receive public comment in. I did update the public comment link under item 3 about a half an hour ago to reflect all of the comments that were received through today. Previously, we had everything that was received through Monday morning. So noting that that public comment has been received and that there were no requests to speak at this meeting, I'm going to go ahead to the next item, which is the staff updates item. And what I'm going to do is call on a number of staff to briefly provide updates on short-term rental registration and enforcement efforts that have been conducted since the first meeting. So if you recall at the first meeting, Ron Kagi and Brad Lundahl gave presentations, and basically we just listened to public comment and working group meeting members at the second meeting. But staff has been continuing to work on this issue since that time, and I thought it would be prudent to give some updates. So first, with regards to registration efforts, Business Services Director Whitney Pitt is prepared to give an update. Whitney, why don't you go ahead with that?
Good afternoon, everyone. Like you said, my name is Whitney Pitt. I'm the Business Services Director. A little less than 3 weeks ago, Business Services assigned 1 license inspector and 1 tax auditor to spend approximately 50% of their workload on short-term rental review. As of today, they have been able to identify over 1,000 locations that either do not have contact information on file or commonly registered with the city. We don't use the word registered, but they don't have that contact information with the city, or they're not licensed with ADOR. They've been identified from various lists that we've been provided and partnered with the police department through public comment in this platform, citizen complaints, and then their own independent research that they've been doing. The staff will be researching payment history via ADOR for those that aren't licensed, and then those may turn into tax audit leads for our department to follow up on. Thus far, those 2 employees have sent 350 letters, and the staff has continued to look at the data received from our utility accounts and getting it into a format that's more manageable for us to process. There's about 22,000 accounts where the mailing address is different from the physical address, so it's taken some time to sort through the data and verify what we can follow up on. After those letters are sent, which they've been sent today and they'll be sent throughout this week, we're giving the short-term rental property owners about 2 weeks, and then from there, we will confirm that they have not moved forward with sharing their contact information with the city, or if they're someone that have not been licensed yet with ADOR. And then from there, we will be completing the manual entry of the ADOR violation form and overall, basically reporting the property owner to ADOR. So we're still working on quantifying the workload to see what kind of return on investment we can expect from this kind of research, since as you guys we've had lots of discussion, but we can't exactly quantify the exact number of short-term rentals in Scottsdale, as it changes every day and we've got a fluctuation. So we can't say when we get to X a number that we've reached it or we're at the max. We're just going to continue processing and then sharing from there what we find. So for now, that's the update that I have.
Thank you very much, Whitney. Carl Eisenberg has his hand raised. Carl, go ahead.
I just had a real quick question. When we talk about a return on investment, is that in reference to revenue for the city? Is that what you meant by that?
I guess it could mean a lot of things. That's a great question. For me, I'm trying to quantify how much time we're spending and how much, whether it's money or whether it's people that we can sign up. I haven't been able to really figure out what the quantifying ROI will be in this case. There could be a lot of different things it could be, but we're just trying to do the best we can and identify as many of these locations as we can. And then from there, see what kind of information we can share with ADOR or what kind of response we get from our letters as well.
And then you also mentioned that you had some question marks in reference to different addresses and contact information. And I inferred from your comment that there might be a point where you weren't able to reach the property owner. Is that what you were, and you didn't know if you couldn't reach them, then I was confused as to what your next action step was on that.
So sorry, that could have been confusing, but what we did was they have about 1,000 that they've identified as being short-term rentals from one way, shape, or form. And then from there, they're sending letters to the addresses that we can find on file. So they're using a variety of different databases. We're giving them 2 weeks to respond, and then we will, whether it's in the letters, we're telling them that we'd like them to contact us so we know, we can follow up, kind of put a nice little exclamation point at the end or an asterisk that we're good to go. If not, from there, they're going to follow up with and make sure they haven't done the steps they're supposed to, double check in their databases. If it hasn't happened, then they're going to send ADOR that violation form and report them.
Thank you.
Yes.
Very good. Thanks, Carl. Thanks, Whitney. Any other questions for Whitney? Look and see if any other hand raises. All right. Then our next update, I'm going to call on, I do have it. Looks like I do have a hand raise. Shane, can you see another hand raise? I'm missing it for some reason, or I saw one go up. Sorry about that.
I am not seeing a hand at this time.
Okay, excellent. So,
I think Mr. Mason, it looks like it has a hand kind of going up and down a couple of times.
David, would you like to go forward? All right, then.
He's muted.
Yes.
Okay.
All right. We'll.
There we are. Can you hear me?
Yes, we can now. Thank you. Go ahead.
Okay. My question was sort of a follow-up on what Carl said. And my question was, in terms of assessing return on investment, are you also throwing in quality of life, impacts on neighbors, the feeling that the Scottsdales are finally doing something about STRs, or is it just a monetary look? That's my question.
All great suggestions and information. I can empathize. That's the goal here, is that we can make an impact. What I'm trying to quantify is quantifying the time and the return that we get from them spending 50%. They're changing kind of what their job description had been and what they're focusing on. So all great questions for us to look into and kind of put what that ROI is. I think that could be over the long term of what we decide and which way this rental working group goes.
Yeah. My main question was, and glad to hear you say that, it's the non-tangible aspects of ROI that are probably equally as important as the financial aspects.
Absolutely. And that's why we probably haven't been able to get an exact answer or goal yet for this, because some of it's quantifiable and some of it's qualifiable. How are we going to get there, those intangibles, and make an impact? So absolutely.
Great. Thank you. Thank you very much.
Thank you both. So the next update I'll ask for is from code enforcement. Either Ron Keggy or Eric Allen, do you want to give an update? And then looks like I do have a hand raised while Ron or Eric prepares to unmute and talk. Ian, you do have your hand raised. Go ahead.
Yeah, just a quick question for Whitney. You said that 2 individuals were spending 50% of their time on this analysis. What are they not concentrating on, and how do you keep this momentum going if some of their regular work is taking going into the background?
Are you asking what are they putting on hold while they focus on this? I'm sorry, I don't think I understood the whole question.
Correct.
Okay, so I can share, and I can even send to you kind of a job description of what the tax auditors and license inspectors do. But basically, this is a priority for the city. It's a priority for me. It's a priority for our department. So it's okay for me right now to have them focus on what this is and how this could be a bigger impact for the city and the citizens. So I can definitely share that with you or provide that of what their job description is and some of the specifics. But basically, this is the most important of what's going on right now. And we're seeing that they're able to make a dent or seeing a large number that they're able to impact. So I can't quite quantify, like I said, what we're getting back or what we are working towards, but we're seeing big numbers that we're able to send letters and hopefully get them to send in their information and get a TPT license with ADOR. And if not, we'll go that next route with them.
No, I'm good with that personally. I liked your answer. Thank you very much.
You got it.
Vice Mayor Janik, do you want to go ahead? You have to unmute first, though.
I just have a quick question, Whitney. Do you have a time commitment as to how long they'll let you have these 2 employees using 50% of their time to help solve some of these problems?
No, and honestly, if this is something that we get some great returns on, whatever those returns may be, or we're seeing that this is the kind of results that we are happy with and can continue, since we've realized a short-term rental can pop up anywhere, any day, or change with the seasons, I'm totally comfortable with keeping them on that task or pivoting what expectations are and just continue to keep the treasurer informed as we go. So I don't have a time frame. We check in actually every day, but weekly with the numbers and see where we're at and what kind of results we're getting.
Yeah, thanks. It sounds like you're off to a really strong start. So that's great news. Thank you.
Thank you. I appreciate it. Thank you.
Excellent. Ron, thank you very much, Whitney, and thanks all who asked questions. Ron, would you like to go ahead?
Yes, thank you. This is Ron Keggy, code enforcement. I'm going to just build off of one thing that Whitney mentioned. After they go through their effort to try to voluntarily get the folks to register either with the city, the county, and then she has the third branch for the ADOR. She'll send us the information for those that haven't responded, and we can start a code enforcement follow up with them, and that will be the enforcement arm of things. We're currently doing that now. When we run across a property, either through some other complaint or a direct short-term rental complaint, the first thing we do is check to see if they're registered with Maricopa County as a rental property. Then we check to see if they're registered with us, the city of Scottsdale, with that required contact information. Brent, am I able to share something on the screen? Can I put a document on?
Certainly, Shane may have to change your status to do so, but Shane, go ahead and take care of that, and I will stop.
Okay.
You should be good to go.
Okay, share screen. And I want to put up a flow chart. Is the flow chart showing? Code enforcement process?
Not yet. It can take just a moment.
Oh, okay.
Although it's not coming up sometimes, so you have to click on what it is that you want to share and then click the little blue share in the bottom right of the window that pops up.
And Share screen. Well, I can't share it, but that's okay. I'll send this and it'll be made part of the file. But let me just kind of walk you through. It's a fairly simple process for code enforcement. It's a quick step. I just wanted to give you a visual, but this is just as easy. So when we open up a code enforcement case for whatever the issue may be, the first thing we do is log it into the computer. It gets geocoded by address. It automatically tells us who the property owner is based on Maricopa County records, and we give it a case number, and that becomes the case number for that particular issue throughout the life of the complaint. We can add additional complaints to it as we go. If we have multiple complaints that come in on that property over time, we basically add to it, because we can, if we have to write a citation, we can do multiple counts on one citation. So we log it in, we give it a case number, it gets assigned to the area inspector. Our city is broken into 8 geographic areas, so it automatically gets sent to the inspector whose area the property is located in. The inspector then does their research and conducts a physical inspection if that's what's required. But they do either one, whether it's researching for the short-term rental registration or the county registration. They do that within 48 hours. If they come across a situation where they are not registered with either the county, the city, either or both, then we issue what's called a notice of violation or a compliance order. Those are kind of interchangeable terms that we use. We issue that to the owner themselves. And again, it's the owner of record that's listed in Maricopa County as the property. That notice of violation it will have a specific time frame for compliance. In cases like this, much like Whitney's, where they're giving a 2-week, we give a 10-day notice, telling people they need to come into compliance. So we tell them what the problem is, we tell them how to come into compliance, we give them a date to come into compliance, and then we tell them what the ramifications are if they choose not to come into compliance. So that notice is usually pretty effective, and that usually gets us to where we need to go. So I can tell you that on all of the notice of violations that we have sent for short-term rental registration, either again with the city and or county, we have had 100% compliance, or what we call voluntary compliance, with no further enforcement actions necessary with the notice of violation. If in some case someone chooses not to comply with that notice, then we have the opportunity to issue a civil citation that would go to Scottsdale City Court, much like any of the other civil citations that are written on the Scottsdale City Code. So then ultimately compliance. So again, I think as I mentioned in the earlier presentation, the goal with code enforcement is always education and compliance. And certainly there are some folks that are out there that probably know the rules and regulations, choose not to comply until they're issued the compliance notice. So again, that's kind of the code enforcement 101 on what do we do when we come across a violation, including the short-term rental. So this is what we do every day. We send out the notices, and we continue to do so with these. I think we're going to be being given more opportunities, assuming that not everybody that Whitney's group comes in contact with will voluntarily comply with the letter. This gives us the enforcement mechanism to move forward and to have them come into compliance. Thank you.
Ron, thanks. And I put up a flow chart, but then I realized it wasn't the flow chart for this process. It was instead the flow chart for the nuisance party or unlawful gathering enforcement. So I apologize for putting up the wrong flow chart in my attempt to be helpful. Ron, please, if you get those flow charts out to me, I'll make sure and update them into the file for the next meeting.
I will do that. Thank you.
Thank you. Carl has his hand raised for a question.
I think you answered the question, but just so that I'm clear, the process that Ron was describing only applied to STRs, a notice of violation that they were not properly registered with the city or county or state. Is that correct?
So yes and no. I mean, certainly the notice of violation as it relates to short-term rentals, that's one area that we enforce. That's one section of the ordinance that we enforce. We have other sections of the ordinance that we enforce regarding short-term rentals that typically have to do with not having their TPT embedded somewhere on the advertising platform. If they advertise, they don't have embedded on their maximum 6 adults, their dependent children, or if we come across a short-term rental that is acting as a party house. In other words, it's only being rented to hold a wedding reception, a party, a golf outing, get together, a corporate activity, that kind of a thing. So yeah, we use the same enforcement mechanisms for those type of use-related activities with short-term rentals, as opposed to just the, I shouldn't say just but the rental registration portion as well. So the process mirrors each other. It just, we fill in the blanks on the notice of violation for what the alleged violation is and take it from there. Thank you.
Okay, because my question, I saw the one thing, Brent, that you'd posted as public comment. I couldn't find it again. It was a note that was sent to Ron and other. It had to do with violations that have been sent in but had no response from code enforcement. And so I think there's I just wanted, and we may talk about this later, fine, but helping Ron's team have the resources available to actually follow through. Because if complaints are made, yet in looking at this flow chart, which I had to kind of, he gets a complaint, he goes to the geocode, then it goes to an inspector, or not. But I'm confused as to why a stakeholder in the city wouldn't be kept in the loop in terms of a complaint. I was confused on that.
Thank you.
That part of it.
One, there was something that was inadvertently shared, and the sharer asked that it be removed. So we did that. But Ron could certainly speak to that issue of how someone might be confused, thinking they had submit a lot of violations on one property, but we're only seeing one in the system. So Ron, can you talk through that?
Yeah, absolutely. And so so that stakeholder, and I've spoken with him on numerous occasions, and the way he would like to see things done is that every time an alleged violation is sent to the city, whether it's to the code, through the phone, email, Scottsdale AZ, in his opinion, a new case should be opened, a new case number should be assigned to it. That's what his desire is. And what I've told him, and what our program and practice and the way we do it is, we open up a case on the original complaint that comes in. Every subsequent issue that's brought to our attention by a resident that is associated with that property becomes part of the record of that case itself. And so, because remember, when something comes to us, it's an alleged violation until it's proved to be a violation, and then it generates the next level of code activity. So when he has sent in multiple alleged violations at the same property, each one of those are recorded into the original case. And again, as I mentioned earlier, instead of writing, let's say it's 10 violations that have been confirmed for the same property, instead of writing 10 individual civil citations, we write one citation with multiple counts for each day that violation took place. So we capture it that way. But again, his opinion was that we should be opening up individual cases for the same property, for the same type of issue that's been reported. And I told him we would explore that, but that certainly is not how we've done business. But again, we can explore that possibility. Thanks.
And yeah, and my point of view is that the consumer, they're busy, they have lives, the stakeholder in the city, a citizen, they don't always know how to do that. And I think wasting code enforcement's time with duplicate tasks is silly. However, educating the public as to how they can see, and I've tested it myself personally when I've gone on and tried to make a violation note, but I never got any information back, but you don't know where to go to find it. And it wasn't a big deal to me because I knew I could have called you and figured it out. But it was just, the systems aren't, I don't know that the right support systems are there for the inspectors and the times that they do that. Digging into how that whole thing is investigated is something I think we need to discuss. We don't have to do it now. Just wanted to bring that up.
Okay, yep. And just one more side note. When a complaint is made through Scottsdale EZ, that which is a separate platform, but it's integrated with our code system. It comes in through Scottsdale AZ. The sender of that information does get an immediate acknowledgement that their issue has been received and that it's being sent to the right department. It could be solid waste, it could be streets, or it could be code. So they do get that first acknowledgement that yes, the city has received your complaint and that it is being forwarded to the appropriate location. But Carl, I agree. We can certainly look at the way the systems work and look for better ways and improvements to streamline this even better. Thanks.
All right. Luis Centella has his hand raised. Luis, go ahead.
Yes, Ron, isn't there a way on the city's website that you can look up the code violations for any particular property and get a status update?
Yes, you can do that. The city's My Neighborhood website, you can look up and you can see a variety of pieces of information that's in their neighborhood. But again, going back to what the other resident that has a kind of the different perspective, his point was just that you go to that map, and it looks like Brent's trying to bring that up right now, and it will identify you can type in the address or you can zoom in. It'll identify the location. It'll identify that there's an open case. It'll identify what section of the ordinance is being violated. It will show you the inspector. It'll show you what the next item or next action is going to take place. What the resident was again the point that he was trying to make was that you can see that what Brent just brought up here, you can see it's the same case number for 3 different issues that are on that specific property. And his belief is that you should see multiple pinpoints on that property rather than just one. In his opinion, you should see 3 of those those push pins on there because there's 3 separate individual violations occurring there. So that's what his point was. Thank you for that, Brent.
Yeah, and here's one where there's actually happens to be a rental registration one. So if you go to scottsdaleaz.gov and just search My Neighborhood, then you can zoom on that and you can have that, and it'll also let you know who the inspector is. So if you want to contact them directly, if you just call code enforcement, I think that number is 48. Well, you can always call the main number, which is 480-312-3111, and ask to be connected with them. You can also call the code enforcement number, which is 480-312-2546. That's correct, right, Ron?
That is correct.
A number I have used frequently over the 20 years I've worked here. So thank you.
Yep, thank you.
See, Bobby has his hand raised. Bobby, you want to go ahead?
Just to clarify what I'm looking at. So at what point do the points come up that we're looking at? Is that just at the alleged violation, or is that after there's been an enforcement looked into?
So yeah, I'm muted. Sorry. So the push pin does not get placed on the map until the first action, affirmative action, is taken by code enforcement. So the case gets opened, but remember, at that point, it is just an alleged violation. And so once the inspector has verified the violation and actually issued a notice, that's the trigger action that places that push pin on the map to identify that there is an active code enforcement case at that location. This one that Brent brought up is actually a really good one to look at, because when you look at the 4 different alleged violations, you can see on the first one it's still open, second one is closed, the third one is still open, and the bottom one has a closed date. So what that means is 2 of those 4 violation things came into compliance, and so that section of the complaint, if you will, has been resolved. So we still have 2 out of the 4 that are open complaints on that property, but 2 of them came into compliance. Thank you.
All right. I'm going to lower Bobby's hand and go to Ian.
Yeah, quick question, Ron. How long do these violations stay on that site? Is there a time that it's all completed and they disappear?
Yes, but I don't know the answer to that. My recollection is, and I'd have to check with our IT people, I believe that once it's closed, that the push pin comes off typically in 48 hours. So it's not immediate. And I know that because I've had people that were in violation say, "Hey, I got a notice from a letter from the inspector saying, thank you, you're now in compliance." Yet the push pin is still still visible. So I think it's a refresh time, and I think it's approximately 48 hours. But I will follow up on that.
So somewhere you have a history of all previous ones, right? That we can't see.
That's correct. The current system that we have has historical data back to 1999. That's when this existing system that was built by the city, by our city's IT people. So we have historical data that goes back to 1999 for every property that has a code enforcement history on it. Thanks.
Thank you.
All right. I do not see any other hand raises at this time. Thank you, Ron, and everyone that asked. And Ron, this will actually be your last meeting of the working group. Is that correct?
Brent, that is correct. Thank you for
Yes.
that. Folks, those of you that I know and those of you I'm just now meeting, I'm going to be retiring from the city of Scottsdale. June 11th is my last day. And I'm actually going to be, I have some commitments over the next couple of weeks. So yes, this will be my last short-term rental working group agenda. However, I'm leaving you in good hands with Eric Allen. Eric is one of the supervisors for code enforcement and probably the most senior person on the entire code enforcement staff. So he's well knowledge, well equipped. He's a resident of Scottsdale, so he's got a lot of inside information as a resident, as well as historical data. And I'm leaving you in good hands with Eric. Thank you.
Thank you so much, Ron, for your many, many years of service and your knowledge. We're definitely going to miss you. Chief Slavin, could you give an update on any enforcement action or any updates you want to give since the first meeting?
Good afternoon, everybody. It's Commander Coffey. I'm filling in for Chief Slavin for a moment. Yeah, so what I can tell you is we had a meeting with all of our crime prevention officers throughout the city and did some more training about the NOV process, expectations, discussions that we've had here at the short-term working group. And I can tell you that our NOV and education has risen throughout the city. And as of last weekend, we can say that some of our reoccurring addresses are coming into compliance. So I think that's a very good thing. And just our continued education and working with code enforcement to fine tune the NOV process. So, we're continuing to work every day with our officers and giving all that information when we come upon a short-term rental to make sure that Ron's group and Whitney's group are aware of it so that we can tackle it by a multi-pronged philosophy. So unless anybody has a question for me, please.
Couple clarifications, and then I know Ian has his hand raised. So my understanding is you are using those crime prevention officers because they are doing the additional research on the history of the property and prior complaints on the property, et cetera, to build the case. That's one of my understandings. So the other thing I wanted to confirm too is that's also my understanding that the police department is using intelligence from social media, et cetera, to try and head off parties and other activities before they actually occur. Can you comment a little bit on both of those? Thank you.
Sure, thank you. Yes, our crime prevention officers are basically the clearinghouse for each district. So the officers over the weekend will turn in a copy of the NOVs, and then the officers or the CPOs then will see exactly how many NOVs that has generated, make sure that we have all the contact information. They will personally reach out to the property management company and or the homeowner and work with them about, what the violations are, work with them about vetting their renters better, meeting their renters, before they come into the property, cameras, lighting, noise meter readings, things of this nature. And then that kind of segues into our intel gathering. So, they're also combing all the social media sites and looking for, parties, advertising parties. And of course, we look at the addresses and then because we know which are the problem addresses. And then if we do see that there's a large gathering with a DJ where they're going to charge, admissions or, for alcohol, we get ahead of that and we contact the property management company and the homeowner. We show them the advertisement and we tell them, no, this is not, a family that's coming in to have a nice weekend. This is an event. And so we ask you to terminate the contract. We are on site with a good visible deterrent. So if party goers come into the neighborhood, we're already there. And we've had a lot of success with deterring these parties and shutting them down before they even get started.
Thank you. And if a resident is having a problem with a party or unlawful gathering type issue, they should be calling 480-312-5000, the police department's non-emergency line, so that someone can be dispatched as appropriate, correct?
That is correct. Again, this is a partnership with everybody in the community as well. And so the more information and intel that we get, then, we can get ahead of these issues. And so, we can do everything we can to make sure that the neighborhood continues to, have peace and quiet. So yes, please call the non-emergency number. That's the fastest way. If you call the CPO, they may not be working. And so that's why I call the non-emergency number, and we can definitely get an on-duty resource to you as quickly as possible.
Yeah, and if an on-duty resource isn't available, follow-up can still be done after to make sure that the evidence is collected from the resident, et cetera, to address that, correct? Exactly.
So what we ask the neighbors to do is, again, like we discussed last meeting, is, at Friday night at 11 at night, somebody calls in and says, there is a large party. Depending on calls for service, if there's medical calls, domestic violence calls, things of a higher priority, an officer may not get there till 2 or 3 in the morning. But what the homeowner, the neighbor, can do is videotape or record what they see. And then they can send that to us and it'll be timestamped. And then our CPOs can go back and issue a notice of violation based on that recording. And so that's imperative to do. We don't ask the neighbors to confront them, and we don't want them to do that, but definitely record what they see, record, traffic in the neighborhood, parking, any violations they see, and we can always go back and issue an NOV. And again, then we can always contact the renters the next day, the next morning, and, have a discussion with them as well and investigate if there's other crimes, other, citations that we can write. So.
Thank you very much, Commander. Ian, you had your hand raised first. Go ahead.
Yes, I did. First of all, Commander, I want to congratulate you because the last time I met you was when you were Sergeant Coffee.
Well, thank you very much. I appreciate that.
Okay. Let me ask the non-contentious question right now first. What I keep trying to tell the neighbors who are next door to party houses is document it and all that kind of stuff. This is the first time I've heard that we can actually have the neighbor send, a video of the noise to the police. And I think that would be a nice thing to get out to the community to say, how do we help neighbors of party houses that are short-term rentals, and give them like a checklist that they go through, like, you know, ask to talk to the police officer afterwards. I asked them, you know, what happened, this, that, and the next thing. So that's a good point. And I think we need to document that and try and get out to our communities. Now, sorry.
I'm sorry, you know, that's a great question. That's a great comment. And we do, you know, all the complaints that we get, all the CPOs and officers should be educating the neighbors on that fact. And what we ask of them is, you know, again, to make a call for service. So they need to call the non-emergency number. And then when they're videoing it or recording it, they need to say what date and time it is. So again, when this goes, if it goes to court, or, you know, it's easier for us to have that documentation, that timestamp, so that we can do the NOV. So I put that in there as well.
Excellent. Okay, so you're not going to like my next question or point then. A year ago, we had a situation in our community, and it was 4th of July, and the neighbor had called the police non-emergency number. He called me because I'm the neighborhood block watch captain. I went down, and we ended up having an altercation with the police officers, who basically said, you know, don't put in calls for service. It takes us away from more important calls, etc. And we left it like that. So that was reported to the police management. Last week, no, it wasn't last week, actually. I saw an email that was distributed through this group that same situation had happened, where a party house and same officer. And basically the officer said, well, what's the point of calling me? There's nothing we can do about it. So first of all, it's great to hear that you're doing education and training, but how do you know if it sticks if we have this repeat of over a year ago? I did send the information to Chief Slavin, who said, oh, I didn't put the two situations together. And I'm wondering if this might be happening more than just in this one instance. So sorry to rain on your parade, but that is an issue, certainly with neighbors who call the non-emergency number and then are given this comment from the police officer that arrives.
Hey, hi, Mr. Jeffrey. It's Rich Slavin. I'm back from.
Sorry.
I apologize for my delay. I had an urgent matter that I had to address, and so I'm here now. And yeah, I'm glad you brought that up. And we did exchange some emails a day or two ago about it. You know, yeah, not all my officers are perfect. They're going to make mistakes. And when those mistakes are made, I like to hear about it. I'm glad that that comes forward so that we can address it. But I can assure you that all my district commanders and their staff have been in briefings, every single briefing, talking about short-term rentals, our process, our procedures, what they're supposed to do. But if we have an officer that isn't following that direction, then we deal with it, and they're held accountable for it. So I will say that I haven't heard any widespread, you know, sort of conduct like this, and that's why I responded to you the way I did. That I was glad that you reminded me, connected those two calls, because it was the same officer, and Commander Regan I think is already addressing it with that one individual.
Thank you. I have dogs barking, so I'm going to go on mute real quick.
Excellent. I'm going to have David go next. And then Ronan will go after him. David, go ahead and unmute. Thanks.
All right. Thank you very much. Thank you. Thank you, Chief. Thank you for all your comments and all the hard work you're doing. It sounds like we're actually making some progress here. I did have a question. I was reading through the response you sent to Mrs. Myers back on May the 11th, where you talked about your documenting issue civil violations after you document 3 or more NOVs within 180 days. My question is, since short-term rental rental properties tend to be each violation is by a different group of people. Why are we waiting 90 days to issue NOVs against the owner? When the owner should be aware of that immediately and have a notice of violation filed against them that they're people that are renting their property or violating it. We tend to get their attention perhaps and cause them to be a little bit more diligent. If you wait 180 days, they just may sleep through it and say, hey, no problem.
Thank you, sir, for that question. Yeah, I think that's just a slight misunderstanding. The process is not to wait 180 days before any enforcement. What in the conversation between myself and Luis Santea, our city prosecutor and legal advisor, what we're talking about there is the NOV process is a notice of violation through code enforcement about these violations. Those can occur immediately on the first visit to a short-term rental or any other location with a nuisance party or the other factors that we do that for. What the 180-day thing was about, if we have return visits to the same short-term rental and we've issued 3 NOVs within a 180-day period, on the 4th violation, we're not issuing any more NOVs. We're just issuing civil citations directly into city court. And then that would continue until they stop violating, basically. And that came on some recommendations from our city prosecutor as a way to enforce and identify repeat offenders. So we're not waiting 180 days to start any enforcement. We're doing NOVs, right away. But if you get 3 consecutive NOVs in a 180-day period, and we're measuring that 180 days from the 3rd violation, not the 1st. Okay, so if you got your 3rd violation in February, within 6 months from there, if you have another one, we're doing a civil citation into city court from that point forward. Now, from the email that you're referencing, that might not happen until the next day or a few days later, because it's going to be my crime prevention staff in each district that does all the record keeping that way. So you might even see an officer issue an NOV on that 4th visit, that then the crime prevention officer, when he does the research upon receiving that, says, now we're giving this a civil citation at this point, and then he'll issue that civil citation. So I can't expect all my officers in the field to have access to the database and all the records that go with each one of these properties, but that's what my district staff is there to do. And so that they'll do that research upon receiving it and then issue citations as appropriate with that tiered enforcement plan.
Well, my question is this, and that is even more troubling, because way I read it was, after the 3rd violation, they receive civil citation, and you're saying it's on the 4th violation. And I'm just wondering why, since SDRs and their nuisance value seems to be a real problem, why don't we tighten and shorten it up so that they get the notice of violation or get the citation much sooner, and just say on it, you get 1 strike, 2 strike, 3rd, you're out. This one says 4th, you're out. I think it may create the idea that the city could be being lenient instead of being very serious about it. That was just troubling. It's why we're waiting 4 strikes instead of doing it on the 1st or the 2nd or the 3rd strike.
Okay, no, I do appreciate that, sir, and we will take that under advisement as we move forward. If that's something that this working group wants to see, we can certainly make those changes.
Okay, great. Yeah, thank you very much.
Thanks. And I'm going to go to Ronan next because he had his hand raised. But some of these issues, like particularly that last one, I think our Deputy City Attorney Luis Santea is probably best positioned to do that. So we'll go to him after Ronan, and he can share his update. Ronan, go ahead and ask your question.
Sorry, I've got another board meeting they're actually hosting here at the hotel, so I've got to pop off. But I want to thank. I know that this is a very sensitive topic, and I know that the city, I appreciate the efforts because on the hotel side, and these are our competitors that are taking money out of the pockets of our hotel owners. But I also appreciate very much the difficulties that are presented to law enforcement, and I appreciate Commander Coffey and the feedback that he's giving us. And I know it's not an easy task to take on. But I just want to share that I've got to hop off, but I'll be back on the next call as well. But I want to thank everyone for their time today.
Thanks. And of course, all of these are recorded and available on YouTube, so you can certainly listen to what was missed and provide any feedback offline as needed too. Thank you.
Thanks, guys. Appreciate it.
Yeah. Luis, why don't you go ahead next and give an update, and also I think respond to some questions that you have seen asked about what the city can and can't do. Thank you.
Good afternoon, Vice Mayor, members of the working group, and staff. First, let me address David's question regarding the NOVs followed by a citation. The purpose of the first NOV is to put the property owner on notice. And remember, we have to treat owner-occupied short-term vacation rentals and long-term rentals the same. So the nuisance party ordinance applies to all of them the same. It's to put them on notice that there's a problem with that property. The second and third notices they get, they'll be assessed a police service fee. So it's not that they're getting scot-free. That's a fee that's basically a response fee. And then finally, they get a citation into city court, which is a civil violation, and the burden of proof on any of these obviously is on the city. And it helps having a history to show knowledge, because incidents and crime can happen at anyone's property without their knowledge. So you want to be able to develop a good case to show that there's a pattern. So by the time the owner is actually getting cited into city court, they'll have received at least 2 police service fee assessments. So it's not going from 3 written warnings to a civil citation. So hopefully that clarifies that one point. The main thing I'm here to talk about today is the verified violation process. I know that there's been interest in that process. I know David has expressed interest. I'm going to try to share my screen with something. All right. So first off, what is a verified violation under state law? It means a finding of guilt or civil responsibility for violating any state law or local ordinance relating to a purpose prescribed in subsection B or F of this section. And the section of the state law section that is being referred to as ARS 9-539. That's the section that limits the city and what it can do with short-term vacation rentals, and also provides some limited authority over them. So a finding of guilt or civil responsibility means that a court has either found someone guilty or civilly responsible for violating one of the subsections in BRF. In subsections, looking at subsection F, those are really straightforward. So it's when a short-term vacation rental is used for a non-residential purpose, such as an event center, a banquet space, for a special event, retail, restaurant, etc. What is a little bit more complicated is determining what is a violation of B1. So that would be any sort of state law or ordinance that violated B1, such as in the case of a nuisance party, that would be covered by B2. But the police service fee is not a penalty. It's an administrative response fee, and it's not adjudicated through a court. So police service fees would not count as a verified violation. They would count if there's an adjudication on a civil citation and the person was responsible for that violation. Now, the city could amend its nuisance party ordinance to no longer have notice of violations and only have civil citations. However, there still is, with any type of semi-criminal or any sort of ordinance where you're prohibiting something, you have to have a kind of a implied knowledge or mental state where the owner has to know that their place is being used for nuisance parties. That's general. That's why the way the ordinance is currently set up is basically an owner gets one free notice of violation where they don't get a police service fee on the first one, but then can be assessed on additional ones to put them on notice. Now, as an aside, the city of Scottsdale has about 15,000 code enforcement cases of all types on a yearly basis. And we get voluntary compliance in all but 30 or so of those cases. 30 are resolved a year in citations. So you get a lot more bang for your buck, but if you can get voluntary compliance, because there is always going to be a lot of back-end costs and resources, not simply assessing, telling someone you have to pay a $500 fine or $250 fine. People are entitled to due process. So it can take months if you issue a civil citation for it to resolve through the court system. Now, I digressed a little bit from what a verified violation is. So we know now that a verified violation is an adjudication on the merits of certain types of state law or ordinance violations. After a court has adjudicated the violation against the defendant, the city has to report it within 30 days to the Department of Revenue for that department to consider imposing an additional civil penalty. The law specifically says we also have to notify the owner, but presumably they were the ones that received the citation to begin with. And the law limits multiplied verified violations that rise out of the same response to incident as one. So we've had some experience trying to report verified violations. And one of the downsides of a verified violation, at least on the first violations, is that the state deducts the amount that was posed on the local level. So for instance, we had one where I believe the city court imposed a $500 fine. So when we reported it to ADOR initially rejected it, saying we can't do anything with this because basically the penalty that we would impose is $500 minus whatever the city already imposed. So the city had already imposed 500, so they weren't going to impose anything. After some wrangling by Ron Kagi, ADR eventually agreed to take it in case they got a future violation. So we don't know what ADR is doing in terms of keeping that on file. Now, ADR, as you get more verified violations, will increase the penalties, subtracting the amount the city might have imposed. So, for example, in a nuisance party ordinance, let's say we got up to a second verified violation. I believe the minimum fine on the nuisance party ordinance is $750. So what ADOR would do on a second violation, on a first violation, they wouldn't impose anything. And presumably if they impose on the second violation, the additional ADOR fine would be $250, excuse me. They also have a provision in the ADOR process where they can reduce the civil penalty if their hearing officer finds that the STR operator has posted rules about what activities the city or town prohibits in their advertising, whether the rules are posted in a conspicuous location in the vacation rental or short-term rental. So actually a good practice for STR operators would be posting these rules in their advertisements and also putting in a conspicuous location at the site. It would help reduce their potential exposure to ADR penalties. Ideally, that would also result in increased compliance because people might follow the rules. Additionally, just as a last kind of aside here, there is a penalty for that ADR imposes when a STR operator fails to include their TPT license in an advertisement. And this section I have on my screen right now is that particular section. So just in summary, the verified violation process, and ultimately on a third violation, ADR could impose a fine of $1,500 or 50% of the gross monthly revenues for that lodging accommodation. However, if the particular STR isn't reporting its income or such, ADR would probably have no way of calculating a 50% of gross monthly revenues. However, since the process is kind of laborious and not necessarily user-friendly, it might take some time to get to a third violation. Now, they're all civil penalties. Keep in mind, imposing a civil penalty, you can impose civil penalties, but they're not. It sometimes can be hard to collect those penalties because a lot of people won't necessarily automatically pay what they've been assessed. It's just with civil citations, it's sort of like a traffic ticket. People pay their citations or they don't. And with a driver's license, it used to be their license can be suspended. The law's actually changing where that's no longer going to happen. So there are various collection techniques that can be used, but unfortunately, and ultimately, it might be easier to collect some of these civil penalties against a property owner than it would be the actual hosts of or renters that are violating things, because eventually you can get to the point where if you got enough civil penalties, you could potentially file a lien against the property. So that might be an effective way, but it needs to be a larger amount to make it a cost-effective process. So one thing I wanted to highlight too, under this ordinance, under state law, 9-539, is the types of things that we can do. And we have to, when it comes to nuisance ordinances, we have to treat them, short-term vacation rentals, exactly the same as owner-occupied and rental properties. With that, I'll take any questions anyone might have.
Thanks, Luis. Scott Bowers has his hand raised. Scott, go ahead. Scott, you'll need to unmute, and then David and then Carl are after Scott.
Okay, sorry about that. I had a little trouble finding the unmute button. A question, one general question and one more specific. When we talk about civil penalties, we're pretty far down the road. Is it possible for us to talk about the service charge by the police for having to go to a nuisance party to be moved up to the first and second? I think this issue was brought up once before. But we can call that police civil penalty, and can we collect that, a deposit for that, from the booking sites, much like they collect a security deposit for the owners of the properties if they damage the house? So there's another fee on here that if you get called on by the police for having a violation of the code of noisy party or parking or whatever, we can have the the booking site actually remit it to the city and get it, in other words, get that penalty up front in a hurry rather than wait for it to go all the way down the line to a civil penalty.
So that's a very good question. So in terms of the police service fee, it's an administrative response fee, so it's not a penalty per se, although people that are assessed that fee are entitled to due process, meaning that we can't assess fees or penalties without some sort of due process. So people are entitled to appeal that, and quite a few people have appealed. In terms of, we have no authority really to regulate such as the marketplace in terms of Airbnb and those online platforms. What could be done is the STR owners or operators could have probably in their contracts, sort of like some of the rental car companies have with photo enforcement. If they receive any citations, the renter of the vehicle is billed. So that probably wouldn't, you probably couldn't pass on the cost of the citation fees because onto your renters, but you could probably build something into your contracts where they were assessed the police response fees and such like that. Now I know I just contradicted myself on the photo enforcement thing, but it would be something that the STRs would have to explore at the platforms and their own counsel in terms of what they can assess. We've seen at least one instance where a person that rented a short-term vacation rental, the owner received a police service fee assessment in addition to the renter, and the owner charged the renter for that fee that was remitted to the city. I hope that answered your question.
Yes, thank you. At another level higher, have we done everything from a legal perspective, even in association with other cities, jurisdictions, to try and find any holes to be able to poke in SB 1350? I've never seen one that's been written where it's ironclad, but we seem to just have kowtowed to this bill that takes away all of our zoning abilities in the city, which would obviously be a great help right off the bat. So have we explored all those opportunities rather than just explaining what we can't do?
So in terms of zoning power is, we don't have any independent zoning power. The case law on that is that the zoning power comes from the state. There are some things as a charter city that we have a little bit of independence from, which deals with elections and how we use our own city property. But in terms of zoning, we can only do what the state tells us to do. And there's a lot of case law on point on that issue. One of the weapons the state has against us is they passed a law a couple of years ago, SB 1487, where if any member of the legislature believes that a city code or city ordinance violates or conflicts with state law, they can report it to the Attorney General's office. And if the Attorney General's office determines that our city code violates state law, they can then send a letter to the state treasurer and withhold our shared revenue, which is, in terms of the city of Scottsdale, tens of millions of dollars. So that's kind of the hammer that the state has over us. But zoning is actually the least effective way in terms of what we can do in terms of trying to do this. One of the things that the League of Arizona Cities and Towns was trying to do in legislation this year was to allow for limits for short-term vacation rentals and spacing requirements and such, so you don't have 10 of them on the same street or such. That legislation unfortunately didn't go forward. There is stuff in the STR law that allows us potentially to have health, sanitation, transportation, or traffic control stuff if the city can prove that the primary purpose is protecting the public's health and safety.
Thank you.
All right, next we have David, and then Carl, and then Bobby.
Thank you very much for coming and sharing your time with us. Your description of the verified violation process confirms whatever all of us probably suspect is it was designed not to work and to protect the industry. But we all know that. So my question, I have a couple of questions here, is looking at the verified violations process. I mean, there's not much we can do with that, but we have transportation, traffic control, and so forth. Who do we have to prove that this to?
It's basically what we would do if we could find an ordinance and What's interesting about B1, it says protecting the public's health and safety, including rules and regulations. And unfortunately, it doesn't say including but not limited to. And you'll notice in section B2 is where they talk about the real meat is the welfare, nuisance, and noise stuff, which we have to apply to all types of occupancies. The way we can prove purpose of protecting public health and safety is actually going back and looking at the issues and that the city of Scottsdale has experienced over the last couple of years since these things have been become legal. The city of Scottsdale there's always been short-term vacation rentals under the table, but they were generally prohibited. And for the most part, when they were prohibited, I think they were operated much more low-key than they're obviously operated these days. So what types of transportation or traffic control or sanitation regulations could we potentially impose? Presumably, if a short-term rental causes more trash, there could be some specific regulations like that. If they cause more on-street parking, or there could be some regulations. But what we would have to do if we were able to craft an ordinance that regulated that, we would have to just have some findings when the city council adopted that ordinance, indicating the kind of past history and why it's necessary to protect the public health and safety. And based on the last few years, there should be the information that could be mined to help support that. But then again, with that caveat that unfortunately the noise and actual nuisance in the heart of it would have to also apply to owner occupied and rental. So that's a different category.
Okay, yeah, because it seemed to me that things like a lot of complaints are trash is left outside, excessive trash, trash bins are left outside. It's left as a property as a mess. And and then the other question kind of correlate on that, which gets into public health. These places, regardless of what they're called, we do have people going in and out of them all the time. And there is no way for anyone to know that these properties are even cleaned. There's no requirement to clean them, nothing to sit. The public just comes in there and it's, laissez-faire. If they're COVID infected, nobody seems to care. Nobody can enforce it. If the bed linens aren't changed, nobody can enforce that. So is there any way we could say, well, yes, because the public is being housed in these areas, yes, it is a residential area, but because we have high turnover, we can enforce that. I don't know if we can do that.
It is possible the city could craft something related to health and sanitation because it appears to be under B1. That's something we can specifically do with short-term vacation rentals. We would just have to we would just need to develop the support for it in terms of why it's necessary to protect the public health and safety.
Because it's clearly the two types of renters. One is making a home, long-term people that just like people that live there. Other is people are not making a home, so they come in with the expectation that the home is going to be safe. And just like any renter is going to come in with the expectation it's going to be safe, but there's less time for the renter for the short-term person to verify that or to care or for anything like that. And the responsibilities of the landlord in a STR are vastly different than those of a short-term rental, or those of the long-term rental. So we might be looking at that as some way to craft it because of the differences in what the landlord responsibilities are. Just a thought.
Yeah, that's something potentially we could explore.
Yes. Thank you very much. Let's go to Carl and then Bobby, and then I think we need to move on to a couple other things. I often underestimate our ability to get through this time. This has been a good discussion, though. Carl, go ahead.
I'll make it quick. I get confused when everything comes back down to the state's legal stance that a short-term rental must be treated as a residential property, meaning the Landlord-Tenant Act does not apply, but it does apply. You say we have to treat them the same as we would treat a owner occupied or long-term renter. Yet on the other hand, we allow transient rules and things that violate the Landlord Tenant Act. So I get confused. Can you take a minute and just review where to find that statute? And I would like to know, is there an intent on your part to get with the Arizona Attorney General and bring clarity to the discrepancy between state law in reference to, you got the Landlord Tenant Act says one thing, and then you have the ability for short-term rentals to have transients, which there's an issue of, most of them are great, but there are those that don't uphold public health, and they don't have the rules. The rules that are in place at a hotel, for example, are not the rules that are in place for a short-term rental. And I get confused. We make that statement, oh, we're not allowed to deal with that. Well, I'm confused as to why you can't challenge that.
In answer to your question, 9-539 is in Title 9 of the Arizona Revised Statutes, and that's the statutes that cover municipalities.
Right.
It restricts what we can do. So we have to treat them as a city the same as a long-term rental. Doesn't mean you have to treat them the same as a long-term rental. It means we do, which means, for example, if you want to trespass someone from your short-term vacation rental and you take the position that the Landlord Tenant Act doesn't apply, that's fine in terms of whatever exposure you have. We just can't enforce that trespass because the state is telling us we have to treat the long-term rental and a short-term rental the same way. The inconsistencies of the law are the way the legislature enacted it. The Attorney General's office is not the legal advisor or the advisor for the city, so we can't ask for an Attorney General position. And an Attorney General position is not binding in any case. It's what they call compelling authority. So people that can ask for an Attorney General opinion would be a member of the legislature could ask. The problem is, even if the Attorney General says, oh yeah, the Landlord Tenant Act doesn't apply, the state legislature passed a law saying cities, you have to treat them as if they are a long-term rental. So I know that's probably a dissatisfying answer for you, but when they enacted this,
Nope, that's a good answer. That's a good answer. So 9-500-0.39 Arizona Revised Statutes, as I see on your screenshot right here. I want to read it and reread it and seek additional counsel. I just wanted to ask. I was just keep getting confused on that. So I understand. You're just like, well, it may be true, but we don't have the authority to deal with it. Okay.
Thanks, Carl. Thanks, Luis. Yeah, I think what's on the screen there is clearly what we're talking about. You can see B1, B2, and B3, and the clarifications for each. Bobby, why don't you go ahead next?
Okay, thanks. Well, actually, let me piggyback on that for a second because I'm not so sure. So it does say here in B that there are some occupancy constraints. Now, and I'm not an expert in the long-term rental occupancy rules, but I would assume it's not 6 adults plus their dependent children. So maybe I could get some clarity on in fact, it's just the opposite of what I just heard, is that the cities can actually enforce things differently between a short-term rental and long-term rental explicitly here, just in the occupancy limits. And also to piggyback on that is, I think maybe even the accessory building, being able to sublet, if you will, or lease out part of it might apply differently, because I know on the short-term side, you can't rent out more than one piece of the property. It has to be rented in aggregate. So I understand that, but is that true also on the long-term rental piece?
So we have to, in terms of occupancy, we can regulate classification, use, or occupancy as long as we regulate it across the board in terms of any residence, owner-occupied, long-term rental, short-term rental. Subsection B1 and 3 are what we can specifically do or regulate in terms of STRs outside of applying those particular regulations to long-term rentals or occupied. 2 B2, which is the meat of this, is we have to enforce use and zoning ordinances, noise ordinances, nuisance ordinances. We have to apply them the same as other property classified under section 42-1203 and 42-1204. I wrote that in. Those are the class tax classifications. And the first one is owner occupied residences. And the second one is rental properties. So the most important ordinances, we have to apply the same across the type of occupancy. But in terms of the exceptions to it are B1 and 3. This is not the clearest law in place, but the intent of this legislation was to limit the ability of cities to regulate short-term vacation rentals. And when we did so, have to only impose rules on them the same as other residential uses, with the noted exceptions of B1, B3, and then also down below F, where you can't use a short-term vacation rental for non-residential uses, such as a restaurant or a banquet.
Sure.
The occupancy level, the occupancy limit of 6 people and their dependent adult children was actually enacted by the city not to deal with short-term vacation rentals. It was enacted by the city to deal with sober homes, and it was made to apply against every single residential use. So it's not something that was specifically created to deal with the short-term rental issue. It applies to short-term residential uses because we have to treat them all equally, but it wasn't specifically enacted for STRs.
Okay, so regardless of property size, the maximum family size in the city of Scottsdale for any property of any size is 6 adults and their dependent children.
That's correct. And the term dependent children actually means adult dependent children. You can have unlimited number of minor children.
Okay. That just seems bizarre to me. That seems like that would be so, but I mean, so just as far as that, I mean, give or take the 6, there does seem to be some leeway, or at least some enforceability or some modification to that number, or why was 6 landed on? What was
the city could change the occupancy limits and make it applicable to all. It had to do with sober homes. So there would be a staff report. I don't have it in front of me when that was enacted. The one thing that you always have to take into account when you're dealing with setting any sort of occupancy limit is fair housing considerations. So I don't know particularly why they decided on 6, but it had to do with sober homes. Other places will have an occupancy limit of like 2 people per room. But the city could certainly change its occupancy limits if the city council so chose to do so.
All right. I'm going to go ahead and go to David and then Scott. Any quick last minute questions on this? That'd be great. There's something else I need to cover and probably give everybody a homework assignment too. So David, go ahead.
All right, thank you. I've got a couple of very quick points. I go back to my conversation on verified violations with Ben Blink when he proudly professed, as has Senator Mesnard, that everything must be working fine because not a single verified violation has been filed. So I realize it's a pain in the ass to file them, but if you don't start filing them, Ben Blink and Mesnard and the STR industry would say, look, there's a process to fix it. Nobody's doing it. So that was my comment there. The second one was on B3 violations, which seem to be fairly serious. It also covers a sober living home. So we don't need occupancy limits to prevent sober living home. We can just say, well, they're limited. I don't know whether it's true or not, but that's one idea. But it seems to me if we treat a B3 violation as escalates immediately to a civil violation, that would get some attention. And the problem, I'll say that because when it hits, somebody could come in, we're going to do a music video with pornography and all like that at somebody's rental property. Well, the owner doesn't really know about that. Maybe he did or maybe he didn't, but the occupant should be cited immediately for that. And subject to that should be a verified violation going back against that because it was what occurred. That's just a couple of thoughts. Anyhow, thank you very much.
Yeah, and we can't eliminate sober homes from the city of Scottsdale. The purpose of that prohibition was to prohibit short-term vacation rentals from being used as sober homes. There's various things under the Religious Land Use Institution Act, the ADA and stuff that basically the Fair Housing Act that requires us to be able to have or not be able to have sober homes. A totally different issue. For some reason, they just, I think, threw that those provisions in there almost as red herrings because we really haven't had issues with short-term rentals trying to do those different things. Maybe some of the events that Commander Coffee talked about earlier might try to sell alcohol, but those particular B3 ones, we haven't so much experienced those.
But Luis, those B3 items are in the nuisance party and unlawful.
That's true. And if you do any of those, yes, you could be cited immediately if the city chose to do that. Yes, that's correct.
Yeah, so we did fully use the provision in B3 and included that in. Scott, go ahead.
Well, thank you. I know our time is short, so I'll be brief, but it would seem to me like the answer to the big problem is in the question, why don't we require 30 days rental on long-term rentals minimum and treat the STRs just the same? Thank you.
I believe, are you asking why can't we require short-term rentals to have a minimum stay of 30 days?
I'm asking that statistically, I would believe that anyone who has a long-term rental is probably 30 days or greater. If we say that long-term rentals must be a minimum of 30 days, you would not be mistreating, or 15 days, you would not be mistreating or disserving the short-term rentals by requiring them to stay the same amount because you're treating them equally, rather than having these transient 1-2 day, 5 days a week with different people. We now put them into the same as the long-term rentals, which requires a 15-day minimum stay. Treated equally.
So we don't believe that under 9-539 that we can limit short-term vacation rentals to minimum stays. We believe that would be a conflict with the state law.
Yeah, I think you're missing my point. My point is that we cannot treat short-term rentals differently than long-term rentals, if I understand that correctly. If long-term rentals are required to have a minimum amount of time, which I believe that they all do, just per, no one's going to sign a lease or a rental agreement for less than 30 days, wouldn't be worth their time. If that is put into the city code, then you could also require the same thing of the STRs because that is treating them equally with long-term rentals.
No, we can't do this, and here's why. Under subsection B of 9-539, city or town may not restrict the use of or regulate vacation rentals or short-term rentals based on their classification, use, or occupancy, except as provided in this section. So the 9-539 doesn't give us the authority to limit the duration of the stay. So basically what happens with the 30-day threshold, that changes your, that's kind of a almost a taxing definition. I mean, it's a good suggestion, what you suggested, but unfortunately, it would conflict with the state law.
All right. Yeah, thank you. Checking. Okay. So what I want to do here, and I certainly didn't intend for item 2 to go as long as it did, but it sounds like we got some good additional information and good questions that related to some of the questions and recommendations that group might be considering. let me give a quick update and then share with you the working group opportunities, and then really ask you to take a look at this between now and the next meeting, and I'll also take some comment on that. So, if you could indulge me for a few more minutes, then we can go through this. I want to let you know too that one of the things that you all had suggested is that we start to use technology to better identify registrations and better manage short-term rentals. We have started setting up meetings with each of the major technology providers to get more information about their programs and the costs and what they'd be able to do. And as soon as we have more information on that, we'll be able to give an update on a future meeting about that. We also are working on setting up meetings with the major online lodging marketplaces as well. One, to talk to them about encouraging all Scottsdale properties listed on their platforms to provide their contact information to the city so that they are doing that proactively. And then also about removing guests, owners, hosts who have violated the city's ordinances. Working on having those conversations, getting those set up. And we're also reaching out to other cities that have had some success either with using the technology platforms or working with the online lodging marketplaces to get more information. So we're working on all those things behind the scenes. I just want to make sure that you knew that not only were we going through the process of working with the working group to get your ideas, but we're also trying to work kind of in tandem with that to try and improve all of these efforts. So I am going to click on the opportunities document that we provided. Shane, can you let me know when you can see that?
I can see it.
Okay. So what we did is, you call last meeting, Shane had taken notes of everybody's comments. And then we took all of those comments and we put the initials of who made the comment associated with that. And then we tried to group them into a bunch of different related categories based on the comments. And so here is what we came up with. And what we want to do with that is, one, make sure that the opportunity accurately reflects the comments. And then we also want to work to develop the steps that would be recommended by the city to start addressing that opportunity. And then we're certainly going to assign staff in particular to follow up on those. And what we're trying to do here is to kind of flesh out what the recommendations would ultimately be like. And we have 3 meetings to continue to work through this, but we wanted to, I wanted to get this to you so that you can review it in more detail, give us feedback on the opportunity, the comments and the steps, and be prepared to discuss that at the next meeting. So as we look through this, Carl, do you want to comment on that before I go through it?
I'm sorry, I didn't want to interrupt you. So just so I'm clear, this is the template by with which you're going to promote and provide your information through the city manager's office to city council. Is that correct?
I'm open to feedback on that. This just happens to be how we took the comments and tried to show how we group them into a number of different opportunities to be helpful to the working group. Because we think that you need to, ultimately, I think we can pull the comments out if needed. I just wanted to include those in so you knew that all of the comments that were made previously are still there and made their way into one of the opportunities, if that's fair.
Awesome. Thank you.
Okay. So, and we did some ranking on here too, based on kind of the perceived importance of what we've seen in the conversations and the comments and everything that's made. So it's clear that one of the opportunities and one of the sets of comments was about improving enforcement against properties who regularly violate the ordinances and sharing information with the state of Arizona about how we are using the powers available to cities. And so that reflects both the enforcement, but also the comments around, I think David just made it a few minutes ago, that there's this perception that there's not really a problem because the state, either because the city is not using the powers available to us or there have been no verified violations reported. So that's the first bucket of things. That's what those are related to. The second is working with the industry to increase registration, improving voluntary compliance, and ensuring there is input from the industry received prior to implementing any recommendations. And you certainly have seen there's interest by the industry to be involved in this solution. I know a couple of you are involved more directly with short-term rentals in various ways. And of course, I've already kind of updated you a little bit on our efforts to that end to try and reach out to them as well. The third set of things seem to be related to using technology to identify and increase registration and compliance. Again, as I mentioned, we are reaching out to a number of the major platforms to try and get more information so that you can take a look and see what those platforms, what those technologies might be able to do. So that could generate a more informed recommendation. Another set of recommendation or another opportunity seemed to be around ensuring that Scottsdale is collecting all allowable revenue from the short-term rentals and analyzing whether the fines could be increased. And then there's a series of things, and I think we've spent most of the time today talking about this or asking questions around this, and that is evaluating whether Scottsdale's ordinances, and the key ones seem to be the vacation rental, nuisance party, and unlawful gathering ordinance, and the noise ordinances could be strengthened to eliminate loopholes and improve the ability to enforce. That seemed to be another one. Then there were a number of them that are related to the information that's shared. We've also talked a little bit about this today. So improving the information and resources shared by the city to help inform residents about what the city can, can't do, and also make it easier for people to contact property managers, hosts when there are problems. So that was about, the general residency. How do we improve the information about this? Then there was one that's more specific, and I think you've seen comments related to this as well. Assisting HOAs in neighborhoods that have CC&Rs but not HOAs with information on resources on how to better manage short-term rentals in the neighborhood. We have a neighborhood college that helps homeowner associations and other neighborhoods out on a variety of issues, certainly exploring whether or not this could be issued as a topic. Typically, that is finding outside experts that are willing to participate in that. And then also another one, a bunch of areas, comments seem to be around improving education about best practices for owners and hosts. And then I think the last, but certainly not least, is the issue around advocating for changes to state law to return oversight to the city of Scottsdale. And you might want to talk more about that and how the working group members and others might be able to work effectively on that. So I can tell you that everything that you commented on last time made its way into this. There certainly may be other ideas that have been thought up that either do or don't fall into one of these categories. So I guess the homework assignment for this in between this meeting and our next meeting 2 weeks from now is to review this in detail. Are there other opportunities that aren't captured yet from the comments? Do additional comments need to be made to create additional areas? And then we do need help, and staff will continue to work on this as well, but to develop the steps that would be needed to really adequately address the opportunity. So that's what we need from each of you between this meeting and next meeting. And then what we can do is really dedicate the next meeting to really fleshing this out and identifying additional areas or opportunities, and really fleshing out the steps. Does anybody have any questions, comments, or observations about that approach? Vice Mayor, go ahead.
I just wanted to say, I think you've really done a great job of organizing all the information. I am super impressed with the effort that our city staff is now putting forward to get this under control. And I'm especially appreciative of all the people that have commented today and are working towards a solution so we can get this under control. So thank you very much to all of you for this.
Very good. We will send out a separate email to the working group with this document in a format that can be easily commented on and captured, so that we can then have that for the next meeting. So we're going to work out the details on how to do that, but we'll send that out in the next couple of days, by the end of this week. We just need to figure out the technology on that. Rebecca, go ahead.
Yeah, is your vision to have us comment on all of them, or are we going to divvy this up somewhat, or what does that look like?
I would imagine that different opportunities are of greater interest to some than others. So choose the ones that perhaps are the most interest to you. We just want to make sure that we've got a comprehensive and good list, because ultimately what we want to do is then work with the group and really make sure that we're refining your recommendations and also getting a sense of the relative importance of each as well. So because I think at some point in time, we're also going to look and identify the costs associated with this and have a conversation about that before we're finished with your work.
Great, thank you.
Okay, Ian, go ahead.
Yeah, quick comment. Are we stuck with the 6 weeks? Can that be extended if there's stuff that really needs to be flushed out a little more?
I think it's possible that one of your last recommendations may be that you need to meet more, but I do want to see what we can do to work on this. We know the urgency of this, and really wanted to have a compressed time frame on this so that your recommendations could get to the city manager, and then ideally could get to the council on as quick a time frame as possible.
Thank you.
How about that for a yes and no answer? Anyone else? All right. So I will go ahead and we will close out this meeting with a couple of reminders. I'm going to go back to the agenda and share that. I guess what I needed to do was just go back to the prior thing that I had shared. So here's back to the agenda. So just as a reminder, again, written public comments, we're accepting those. We're getting those all uploaded so that everybody's comments is shared with the working group members and any interested parties. We will continue to allow spoken comment at the meetings. So those spoken comment requests are accepted up until an hour and a half before the meeting. And the primary subject at our next meeting will be the discussion of this working group opportunities list. And certainly there are other resources that are there. All of the resources from the past meeting are still online on our working group page. And again, if anybody has any questions in the interim, feel free to reach out. Thank you so much, especially for the extended time. And we'll see everybody 2 weeks from now. Take care.